Раз, два, три.
Well, distinguished ladies and gentlemen, dear students, guests, colleagues, we are starting the second part of our discussion. I understand that after lunch it's very hard to do, especially to sit in the auditorium and speaking about very, very profound characteristics of what international criminal justice is and what we have to do with that. I just remember the fact when, just to start, when we were preparing our internet translation, just I remember the fact of my own life. It was autumn, a very cold autumn, that's November. November is just the end of November. Yes. Okay, it's not, there's something outside. So that was November, there was Ministry of Interior, there was a great amount of people, and people are sitting after the lunch and they begin sleep because the lecturer was murmuring. And I just began a lecture and began a lecture in English, and that's why they tried to open their eyes because they can't understand where they are. You know, you understand where you are, you know that we are now trying to begin a second panel discussion, and Dr. Omar Ba via Skype will try to reach a new milestone. As for me, for the theme of the Icc is testament to hope and symbol of deception. I don't know whether it's right or not, but what I can say about international justice and post-colonial tradition, some people understand it via the concept of development. But some people understand it via the concept of happiness. And for example, as for me, the right to be happy is more comfortable to understand than the right to develop. And the well, some people in theoreticals in the United Nations say to develop, the right to develop is the modest right to do. But in African philosophy, in the philosophy of countries which are located in Latin America, the right to be happy is more sophisticated and interesting. And sometimes when we say about the understanding of international justice in post-colonial condition, it is more obvious. And that's why I present the floor to Dr. Omar Ba, and I hope that everything will be clear with our connection.
Yes. I can hear you perfect. Thank you all. I want to first start by thanking the organizers of this conference. It is an honor for me to have been invited to share my research with this audience. My presentation today is titled "The ICC as a Testament to Hope and a Symbol of Deception, International Justice and the Post-Colonial Condition." Let me first start by saying that I am not a lawyer, I'm not a legal expert, I am a political scientist. So I approach these questions from a political science perspective and a post-colonial theory and critical IR. That said, I also want to mention that I am not here to represent the African position about the ICC. I don't think that there is one position that Africa has taken. There are diverse opinions about what the ICC does. So I'm merely presenting my own research here and speaking for myself. That said, last year, the ICC moved its headquarters into
the permanent premises. On that day, the UN Secretary General Ban Ki-moon said that the new home represented a co-chair, a milestone in global efforts to promote and uphold human rights and the rule of law. The President of the Assembly of State Parties remarked that it is a historic day, but also a day of hope for all victims of mass crimes in the world. And the ICC President Judge Hernandez announced that the code was here to stay. Indeed, the Office of the Prosecutor has reached a milestone when it finally opened its first investigation outside of the African continent, in Georgia. And there are currently 10 situations at the preliminary examination phase. 15 years after it came into existence, it is true that the ICC has achieved some successes. But it has also faced drastic failures. Its work is still constantly in flux, as it is still setting its mark on global politics and conflict processes. And as Carstenstein actually put it, I believe the ICC still stands. Despite critics and despite its shortcomings, it still stands as partly a testament to hope and also, unfortunately, partly as a symbol of deception. And I will explain what I mean by that. Among the ICC shortcomings, we can note the issues of timing and delayed action in Darfur, for instance, the conduct of investigation in Sudan, the mistakes that were made by the prosecutor in the Ugandan rebel. Preliminary examination cases have grown significantly over the years, some of them having lingered for many years without much progress. Charges were not confirmed at the pretrial phase in some cases or withdrawn by the prosecutor. Some charges were dropped or cases terminated. The ICC is also criticized for its failure to take on hard cases that would threaten powerful states. And here I'm merely quoting Bill Shabazz. The relationship with the Security Council has been marred with disappointment and political rambling. In many African countries, voices of concern critique the ICC as an instrument at the hand of Western powers pursuing a neo-colonial agenda. But on the other hand, states, especially African states, and I want to be clear about this, African states were able to devise strategies that allowed them to use the ICC to defeat, whether militarily or politically, their adversaries or opponents, be they opposition leaders, warlords, or rebel groups. Outsourcing justice becomes Therefore, the mechanism through which applicant states have used the ICC. They were able to use the court because of its focus on individual criminal accountability in a state-centered global system. And we know that atrocity crimes tend to occur in situations of conflict or unrest, and they are likely to be committed by a large number of individuals, including agents of the state. This feature of the ICC raises questions about whether the current neoliberal international justice system is not working to exonerate states and their agents and discharge them of their responsibility, not only to provide safety and protection, but also not holding those agents of the state accountable for committing war crimes and crimes against humanity. For instance, the case of former child soldier turned LRA commander Dominic Owens is telling. As the program coordinator of the Actually Religious Leaders Peace Initiative in Gulu, a civil society group in Gulu, Uganda, he told me, we, the Actually people, don't say that Kony and his commander should be set free, but our constitution puts the government of Uganda in the position of protecting the lives and property of its citizens. So if the LRA comes and abducts 200 people in this community, then it means that the government has failed in its role to provide security and protection. And of course, as it has been also widely documented, the Ugandan army has also committed many atrocities during their fight against the LRA. Prosecuting those crimes fits within the mandate and jurisdiction of the ICC, although the prosecutor has focused only on rebels. The question we ask, then, is whether the ICC is equipped to hold the states and their agents responsible for victimizing civilians, or is the state-centered international justice system just a smokescreen that shield the states of their responsibilities as instruments to further their own interests? And the ICC is no exception to the rule. Moreover, the ICC interventions in Uganda, the DRC, Kenya, and Cote d'Ivoire show that the court is nearly incapable of successfully prosecuting high-ranking state officials. Although the ultimate goal of the ICC is to end impunity wherever atrocity crimes have been committed, it is apparent that the international justice is selective and marked by double standards. We live in a world in which there is no equal prosecution of those most responsible of atrocity crimes. The most powerful states are still out of reach of the ICC. So are their clients, with whom they share economic and social ties. we must also take into consideration the ways in which these states devise strategies to circumvent it and bend the rules to fit their calculations. Because all current ICC cases under investigation, except for one, are located on the African continent, it would be easy to conclude that the ICC is biased against Africa. But of course, there is no conspiracy in The Hague to prosecute Africans. In many of these instances, in Uganda, the DRC, the Central African Republic, Mali, and more recently Gabon, the ICC intervention has been triggered through self-referral under Article 14 of the Rome Statute, which means that the state party writes an invitation letter to the ICC. Cote d'Ivoire, as a non-state party at the time, submitted an ad hoc request to the ICC under Article 12.3 of the Rome Statute.
This means that in all these situations, the state where the OTP has opened a preliminary examination or investigation, it did so at the invitation of the states. Kenya, Darfur, and Libya, of course, being the exceptions here. Therefore, I will say it again, I don't think there is a conspiracy
in The Hague to target Africans. However, when this question is placed more broadly in the context of international criminal justice, I agree that the ICC is a testament to hope, but also a symbol of deception, because it fits in the narrative and legacy of international law and the theory and practice of international criminal justice. International law and the current international justice system lie on foundations that consecrated the West as the sole trustees of law, justice, and morality. I project that the post-colonial condition is the one in which the globally disenfranchised navigate the international justice system, which makes them bound by the rule of international law without necessarily its protection. Indeed, the West is still incapable of committing atrocity crimes. International law, by essence, is universal, as it regulates relationships among states regardless of their cultural systems or political organization. Yet, the universality of international law is a recent phenomenon, dating only from the end of the 19th century to the age of empire. By the start of World War II, virtually all territories in Africa and Asia and the Pacific had become integrated into the colonial possessions, and all under the tutelage of Europe, bringing them into a system of laws that were fundamentally European. At the same time, positivist international law distinguished between civilized and uncivilized states. Indeed, positive jurisprudence in international law legitimized the conquest and dispossession. And here I will quote Anthony Ng, who said, "The violence of positivist language in relation to non-European peoples is hard to overlook. Positivists developed an elaborate vocabulary for denigrating these peoples, presenting them as suitable objects for conquest and legitimizing the most extreme violence against them, or in the furtherance of the civilizing mission, the discharge of the white man's burden." End of quote. International law evidently codified and legitimized the imperial project, emerging as a result of the colonial encounter between Spaniards first and Indians or Native Americans, to mediate the dynamic of difference between the sovereign Spaniards and the non-sovereign Indians. The same dynamic dominated relations between the civilized and the uncivilized during the colonial period. committed only by certain kinds of people, those whom international law has sought to control. Alternatively, the West is exonerated from the capacity of committing such crimes. Current international norms show the limits as means to international justice, which is why the ICC is just one of many instruments of international justice that perpetuates the colonial legacy upon which international law is founded. As Fanon reminds us, confronted with a world configured by the colonized subject is always presumed guilty, placing the colonized outside of the boundaries of humanity, subjected to but not protected by international laws. The post-colonial backdrop from which one reads international law enables us, for instance, to better grapple with the silences and erasures that accompany this liberal discourse on human rights. Beneath the contemporary theories of international society and human rights lie disturbing silences, banalization, and erasures. And these silences, banalization, and erasures are salient in the practice of the ICC, as the major global events in the last decade show us. Indeed, the ICC apparent geostationary orbit over Africa masks the many occurrences of international crimes committed elsewhere around the globe. Regardless, Africa has emerged as a space for legal, moral, and political experimentation. There is a historical pattern wherein Africa has been a site for political experimentation without full consideration of its consequences. These experimentations range all the way from the Congo Free State, the Belgian Congo experiment, to the mandate and trusteeship systems under the League of Nations and later the United Nations, to more recently the responsibility to protect experimentation in Libya in 2011. And let me conclude here by saying why do I believe that the West still does not commit crimes, and this is post-colonialism continued. These days, moral failures of the West or its violations of international criminal law are rationalized through faulty intelligence reports or in the name of national security. Instead of a justice system holding Western perpetrators or their friends of mass atrocities to which they are accountable. On the other side, the post-colonial condition on which the non-West is embedded in highlights the impossibility of comprehending the decriminalization of Western atrocities. The legitimacy of the ICC is tested by its inability to create the impression that war crimes, crimes against humanity, and genocide can and will be prosecuted regardless of who commits them. It is through the prism of the post-colonial condition that one can make sense of the post-Iraq war criminality and the aftermath of the war on terror, and still comprehend why the ICC does not have the will or the means to investigate and prosecute breaches of international law, mass atrocities, and human rights abuses. The ICC's inability and/or unwillingness to investigate and prosecute crimes committed by Western coalitions is just a continuation of the situation in which former international tribunals operated. The ICTY, for instance, had failed to investigate I quickly concluded that it was impossible to investigate NATO because NATO and its member states would not cooperate with the tribunal. They would not provide access to the files and documents. I had collided with the edge of the political universe in which the tribunal was allowed to function. End of quote. It is telling that the ICC will not investigate NATO's 2011 campaign in Libya. The prisoner abuse in Abu Ghraib in Iraq and Guantanamo Bay, the CIA torture and rendition program, and so forth are all outside of the framework of accountability and outside the purview of international criminal justice institutions. The ICC's track record highlights the ways in which the African model is subjected to international law within a discourse that exonerates the West as a perpetrator of atrocities. In the end, international law and international justice are still constrained by the power structures derived from colonial history and shaped by the post-colonial condition. And I will end there. Thank you for your attention, and I'll be happy to take any questions.
Yeah. Well, thank you. Do you have any questions? No, maybe because our presenters wrote and we're just internet, it would be better to raise your questions or problems concerned with the speech of Mr. Omar Bo now, not after the end of the session. It will be simpler, I hope. Do you have any question, any suggestions? Welcome. Any ideas? Okay, well, thank you very much, Sir, for your positive rising of the second way of understanding what the international criminal justice is, and I hope that this position is one of, not one of the main, but one that raised by mostly politologists or sociologists and so on and so forth. Sometimes when we begin to speak about not only international, but domestic law, domestic criminal law, there is a gap. Some people say that criminal law and the ideas of classical criminal law, like the ideas we have in international criminal justice and criminal law too, well, they are concerned of in the way of conspiracy, yeah. Because sometimes we say that, wow, guys, what we have to do with the criminal, for whom the criminal code is written, or for whom is written the Rome Statute. Is it written for the people? For the ordinary people or not? And some people said no, because we have to say that at first domestic criminal codes or domestic documents in public law are constructed especially for state powers. For example, could you tell me in international law or the Rome Statute, for example, does somebody say that homicide is forbidden? No. We say that we have the powers to communicate, we have the powers to at one point of view to penalize and to treat offender. And these powers are given to this specific specific organs. That sometimes it would be the kind of the state construction, sometimes it would be something else, but sometimes it begins on the philosophy of understanding what crime is in domestic or international manner. Doesn't matter. The case is the same. On what philosophy we construct the ideas, on what background we are trying to construct the ideas. Sometimes just, in my experience, I have only one dissertation, one PhD thesis, yes, in this country, which was constructed on Hegel's dialectic, because everybody said about materialistic Marxist approach where, that is the former Soviet Union, that's the former Soviet tradition to make Marxist dialectic at the beginning. But when we said about Hegel and the Hegel dialectic, we are trying to understand the second when, and second approach, when the people, people's opinions, people's cases, people's attitudes are the first place, not the state and the state characteristics. The same we have in the international manner, and sometimes we said about that when we are trying to reach new goals or new milestones in the characteristics of international criminal justice. Just have to understand that. Some people will say, well, when I just began to speak about the development and development process, we know the United Nations makes great efforts for 30 years plan of development in such ways of rising up awareness and so on and so forth, making life better in the whole world. But from the other points of view, the Western democracies are based on the Western way of life and the Western understanding. Sometimes it is not connected with the proper understanding of what we are having to do in the field. And that is why from the different parts of the world, the different, dialectics means that we have different ways of what the process is. I don't know whether it is right or not, but for example, in Great Britain now, they want to spend more than £1 billion per 20 years for making their criminal laws easier to understand. They have 400,000 crimes in the country. And that is why they have to make their criminal jurisdiction make it more softer to understand to ordinary people. And that is the new way. The new way, but for example, we have the same in when I say about the Universal Declaration of Human Rights, when the first plain version was prepared to the children 30 years ago in Switzerland. I was one of the members of this team. I remember this word, how it's very hard to do to make a plain version to the people. And that is the case because the crime is a social and legal construct. And socially, it is constructed in the midst of elements which we can't use together, not being pushed on a proper way, on a proper philosophical platform. Maybe, well, thank you once more, Mr. Omer. I want to say some words about my presentation, but I do hope that it is not connected only with the, just try to understand, it's not connected with only the characteristics and the activity of the International Criminal Court, because as for me, the international criminal justice is a subject of more wide interest, and it is connected not only with the grave crimes against humanity, war crimes, but exactly it is connected also with some kind of transnational crimes, like it is done in all the decisions of United Nations Congress on crime and the treatment of offenders. So, 3 or 4 ideas I want to share with you. First of all, my presentation is named as the victimology of the international law. Not the idea of the rights and needs of the victims in law, not the idea of the law on the rights of the victims. These problems are mostly understandable by the whole society. Sometimes one could say that there's 3 dimensions or 3 ways which were used for understanding of what victimology or what some process of analyzing law is. The first one is traditional legal. The second one is connected with misuse of law. Sometimes we do forget that misuse of law and, well, all of the kind of activity which are connected with the political processes, with abuse of law, are forgotten. These are not a crime, these are not a constitute a violation, but sometimes it is mostly obvious and mostly popular in some dimensions, while when our jurisdiction, the jurisdiction of the state, can't be working. For example, let's look at Ukraine. We have the territory which is controlled by the government, and we have the territory which is controlled by the invasion from the side of one foreign state, and we have the territory which is controlled by an armed forces. And that the territories which are controlled by the armed forces, they have a specific jurisdiction. A specific jurisdiction which is null and void for us. It is no law at the Hegel's word. It is anti-law. But they have their own criminal codes. And they work with these criminal codes. The criminal codes of Donetsk Republic of 2015, the criminal code of Luhansk Republic of 2014. These are the documents they work. And these documents which work with the help of quasi-judges, quasi-system. And one could analyze what we have to do with that. For example, I don't know what they have to do with Transnistria. They have their local documents, as well Moldova just ratifies the Rome Statute. What jurisdiction we have under Transnistria's law and the Transnistria's situation? We're located just 30 miles from this border, and I understand that sometimes the violation of human rights in this region are of great impact up to the region as a whole. And that is why this violation gives the third approach we could do, the approach which is connected with law, no law, and misuse of law as the common system. And that is why when I say about international criminal law in this field, one could say about this mixture. We don't know what I have to say, for example, for Guantanamo prisoners, and what I have to say about secret prison and so on and so forth. That is the second, third, another way of understanding what I have to do for strengthening the criminal justice. But from the other view, we have to say that all of this discussion could be overridden, could be faced from one point to another, and this point is the rights and needs of the victim. Providing a victim's rights in international criminal law, as for me, that is the aim of preventing international conflicts in the future. Some people say that victimology, that is the path of treatment of victims of crime and their role in criminal behavior and so on and so forth. Well, that is true, but victimology of law means that we are trying to make a normative approach in victims' rights and needs. Yes, from the traditional normative approach, we said that the United Nations Declaration of Basic Principles of Justice for Victims of Crimes and Victims of Abuse of Power, the United Nations Guidelines for Justice in matters involving child victims, and as for me, is the main document in international criminal justice, which is hidden, it is forbidden. When we say, everybody is saying about the UN Declaration, Basic Principles of Justice for Victims of Crime. This document of 1995 is very popular and very trendy. I was one of the experts who, I'm proud of it, but I was one of the experts who just prepared a textbook, United Nations textbook on this declaration. But from the other side, this year in 1995, the United Nations General Assembly has adopted another document, more interesting and mostly sophisticated in the field of international criminal justice, which is was based upon the ICC and the ideas of ICC. I mean the United Nations basic principles and guidelines on the right to remedy and reparation for victims of gross violation of international human rights law and serious violation of international humanitarian law. That is a very interesting document. The document where the analysis of the elements of the rights of the victims gives another glimpse which in international victimology we can't do. For example, the Rome Statute requires the establishment of principles relating to reparations in respect of victims, including restitution, compensation, and rehabilitation. UN required established a trust fund, and this trust fund for victims of international crimes was done, is working. Judge Saska said about the problems, he said about the 1% of implementing of the idea, but the idea is, and it is working. That's the main. It's working shortly. That's the first steps, the very short steps. But try to understand. In this country, 25 years ago, we just prepared a new legislation on compensation of victims of crime. 25 years ago. We have 2 state programs. We have 5 or 7 drafts of law. We have 2 articles in our civil code, Article 1177 and Article 1178, when the state is obliged to compensate all the assets which are connected with the crime. But to permit that, everybody said that is not in the world, because there is no possibility to do that due to the economic tradition. On supranational level, I want to say that international criminal justice, international criminal victimological processes, we have a very interesting document which, as for me, that is the future of understanding what I have to do with the victims of crime in transnational, supranational, or international level. This name of the document is the Directive 2012-29 of the European Union, establishing minimum standards and rights, support, and protection of victims of crime, which, under normative approach, gives all the interesting moments concerning the rights of the victims. The another point, the point that I'm interested in more, is the standard gap between the characteristics of the victims, especially international victims of crimes, and hybrid or virtual responsibility of international society. The case is that in transnational crimes are so many victims. Sometimes the state is a victim too, and the collective victims, like a state or social groups like in Rwanda, the acts of genocide, we can't say and can't collect every victim. Sometimes we have the another process, sometimes we have the overreacting or overwhelming when one point of coin reverses to another point, and former victims became the criminals under the jurisdiction of the international court. That is the case because that's a very complicated question to understand what we have to do with that. And global respect and global regret to every victim from the position of Africans or from the position of Europeans deserves the third approach, the sensibility, the sensual approach of what victim is. As for us, for Europeans, yes, that is understanding. Or just sometimes it's not understandable too. Well, I remember the fact when I was young, well, that was the first my victimological conference, which is one of my scientific advisors and former teachers, Professor Emilio Viana, who is the president of International Criminological Society, has attended. It was in Spain, and my American friends are discussing the problems of Well, psychological trauma from of policemen who just look at family violence. This was the period of time when the Soviet Union was collapsed. We have tanks in Baku, tanks in Vilnius. We have demonstration. We have blood on the streets and so on and so forth. And we were discussing the problems of post-traumatic stress disorder of policemen who were involved in family violence conflict. Different approach, different understanding, yes, different senses, but these senses are equal. And equality of the senses means that the victim in Africa has had the same rights and the same sensibility and sensuality like the victim in Europe. Sometimes it's not understandable, especially when we say when we talk about the victims' rights and victims' abuses from in the communication level. Pardon me, but when we have a terror act in Paris and terror act in Turkey, these are the same terrorist acts, but these are not the same in understanding of the mass media. Because for the media, it is interesting to say about the French and French victims, not about Turkey victims, because in Turkey this process is mostly common. And we can't say anything about the situation, for example, in Rwanda. In Darfur, it is obvious, but that is affecting only International Criminal Court and international prosecutors' offices who are working here could do that. Now we have only one mechanism. We have the proper understanding of what we have to do with that. But we have to do it. We have to solve that. We have to make a suggestion in the field. Sometimes we have a very interesting moment which are connected with the sensuality. Just try to understand that. And in Rome Institute, there was one question that Kant shared again among this is the international society. The case of inspiration. What does it mean? Victims' rights which were given in The Hague are connected with the right to participate in proceedings, the right to request reparation, and the right to legal representation. That is great. But the word is challenged, and that's why sometimes one could say about symbolic reparation or the right to satisfaction. Do you satisfied? Do you understand yourself as a victim? Do you satisfied with these elements which government, media, other resources like other society, not only society, but civil society should do? Sometimes we can't. Sometimes, and the United Nations says that the symbolic reparation is connected with the specific effective measure with the cessation of continuing violations of their right. These measures are represented, now they're represented in all the international documents. I don't want to put them all, they mostly 12 or 17 specific measures, but if you want, you will get it. The idea is that the rights of victims should be emphasized as the whole rights of the mankind, because the mankind is the main victim of the international transnational crimes. The safety of mankind sometimes should be better understandable via this process, because the object of the crime, when we say about the safety and the safety of the mankind as a whole, well, that is the new approach, the new holistic approach. We are trying to unify all. And that is why the legal rights in the area of victim protection give the new possibility to understand what they have to do. As for me, it's very interesting. One more question is mostly interesting as for me. Well, it is not a revolution to lawyers, but try to understand. In cases of the European Court of Human Rights, Wilson against United States, and then Hutchinson against United States, so the ECHR, pardon me, has created a new paradigm, a new shift in the law of human rights, a paradigm of the right to happiness. The right to happiness, which was at first made by ancient philosophers and then by the Constitution of the United States of America, has to be realized in the idea that we have the right to be protected. And the right to be protected means that sometimes we have the right to be punished too. Not to be protected. How do you understand the right to be punished? It means the right that you have the right to be punished by the fair trial. Not but by the civil society. You know that, for example, here in Ukraine we have a very interesting process, yes? Garbage judgment, when some people were taken and put into the garbage. And they say, wow, that is, the civil society works with these people because they are corrupt officers, they're the representatives with the old powers, and so on and so forth. But I don't know why in present democracies we have such processes. That is the abuse of powers, and this abuse of powers could be understandable from the point of view of the victims of abuses. This approach means that we have to, as for me, we have to reconstruct, just begin to reconstruct the domestic criminal codes when the first block can't be connected with the ideas of what the crime is, what the responsibility is, what the jurisdiction is, but the first block can't be connected with the sanctions. How could people be penalized? How could people be under-victimized? Because the sanction means that victim has the right to be involved in. That is not an ancient period of time when we're trying to understand what I have to do with that. But the law of Talion, you know that. That is the new era of understanding of penalizing process with the help of the ordinary people. The penalizing, well, maybe sometimes one could say that when now we say that the impact state order or a protecting order in the victims protective order in Europe, that is something new and something understandable. But try to find the one motto. 20 years ago, European warrant was not understandable by anybody. We say, okay, it's impossible to do, but it's a reality now. That's a real, well, points of standing up to new era of new justice. The Commonwealth, the justice of Commonwealth, supranational, international, but the idea of safety, of world safety, has connected with this idea, with the de-victimization of the sphere of legal, de-victimization of the sphere of social. Well, sometimes one could say about the process which are stressed on specific methodological approach in the field. I don't know where it's right or not, but 10 years ago, one of the famous, not 10, but 20 years ago, one of the famous Russian scientists who was the first, professor who began to study victimology in the Soviet Union, yeah, Mr. Frank, he said, that this was the last phrase in his book, the victimology of today, that is the criminology of tomorrow. And that is the case that we are trying to understand the new era of international law in the field of victims' rights and victims' approach. I don't know whether it's right or not, but we are trying. Let's try. Maybe you share some ideas in the field. Thank you very much. Maybe it's, I don't know what we have to do with the situation now. Do you have the internet connection for the next? Dr. Irina Marchuk, no, she's in Copenhagen. Hi, how are you doing?
Yes, great, thank you. Can you hear me?
Well, thank you. You're welcome to National University Odessa Law Academy. I'll give the floor to you for the beginning of your report on the International Criminal Court's 15th anniversary and the ideas which we want to share with us. Thank you. Welcome.
Okay, thank you. First of all, thank you so much for inviting me. I apologize for not being able to be in Odessa today. It's such a rainy day, and I just checked the weather in Odessa. It's a glorious sunshine, so I wish I were with you instead of sitting here in Copenhagen. Unfortunately, I couldn't make it as I have some conflicting teaching commitments, but I hope to make it and visit the Odessa Law Academy next time. As you already made it clear what's the topic of my lecture is, I'm aware that I have only 15-20 minutes. And of course, I won't be able to cover all the constraints and challenges encountered by the International Criminal Court. And I'm sure that during the first part of the day, you have already covered a really good ground. I saw that you have eminent speakers presenting on the topic. Judge Ushacka, with whom I had the pleasure to work in 2012. So special greetings to Judge Ushacka from Copenhagen, as well Professor Gnatovsky, and I'm sure that they might have already said few things that I would like to mention in my talk. So I would like to be quite brief. So the major two issues that I would like to cover, it's the perceived politicization of the International Criminal Court, in particular focus on their prosecutorial discretion with respect to the choice of the situations. And the second part of my talk, I would like to say a few words about performance indicators that have been discussed over the last few years as a tool to be introduced to measure the effectiveness of the International Criminal Court. As we know, and it's not a revelation to anybody, that the International Criminal Court has been undergoing existentialist crisis, and particularly at the end of 2016, when 3 member states decided to serve their withdrawal notice and depart the International Criminal Court. Fortunately, this hasn't happened. Although South Africa, Burundi, and Gambia decided to leave the International Criminal Court, at the end it's only one country, Burundi, which is on the way out. Whereas South Africa and Gambia have already revoked their decisions to depart the International Criminal Court. As well as some other African countries such as Kenya, Namibia, and Uganda, they as well noted their desire to leave the court. But so far it's all up in the air, and despite the predictions that there will be a mass exodus of states from the jurisdiction of the International Criminal Court, that has not happened. But of course, the issue of the attempted mass exodus of states from the International Criminal Court has brought the functioning of the court into the spotlight, as there have been concerns about the perceived bias, in particular exercised by the prosecutor with respect to the choice of the situations. And of course, there have been concerns that attempted withdrawal is the sign that the International Criminal Court is losing its credibility and legitimacy on the ground. So what can be done about it? Of course, one can say that it's true when we look at the situations that have been chosen for the prosecution, that they have been focused on African states, and there have been these arguments advanced in media and in academic literature as well, that the ICC is just pursuing its policy of neocolonial witch hunt against the African states. But one can say that when we look at the situations that are currently under preliminary examination, they go beyond Africa. And in particular, we have 10 situations, including the situation of Ukraine that may be potentially considered by the International Criminal Court. We have some other situations under preliminary examinations that the prosecutor has been looking at, but she's being criticized for being very slow about the progress of her inquiry. And I would like to mention few situations that where I think the ICC prosecutor should speed up her efforts and try to decide whether she would move those cases further. And that's the situations of the misconduct of UK forces in Iraq, that the situations of the misconduct of Americans in Afghanistan. Then we have the situation of Palestine, and as well we have the situation situation in Ukraine. So what are the major areas where I think the prosecutor can improve her work? First of all, I think the prosecutor has been sitting on some cases for a number of years. And this is quite unfortunate that there is very limited public information which is available to know what actually has been happening. And there have been speculations that it's imminent that the situation into Afghanistan will move forward, but so far this has not materialized. So I think that the prosecutor has to be cautious that she has to abide by some time limits, and as well maybe be more transparent about her work, exactly what has been done on the ground. The another suggestion was that if the prosecutor knows that she will not proceed with certain situations, there should be some exit strategy available. And it doesn't seem that the prosecutor has such exit strategy. It seems that in some situations the prosecutor sits on those cases for a very long time while not having any real intention to take this situation further. Another suggestion has been that there should be a greater cooperation between the pretrial chamber and the ICC prosecutor, even at the stage of preliminary examination. And there should be some degrees of judicial oversight that should be introduced to make sure that the situations under preliminary examinations are being considered in due time. One of the suggestions that I made in one of the latest pieces that I authored is that in the when the prosecutor looks at the situations under preliminary examination where the conflict is still ongoing, she should prioritize these cases. And as well, I made this argument in the context of the situation in Ukraine. I said that the prosecutor should definitely prioritize handling of the situations under preliminary examination when the conflict shows no signs of abating. So this is just a few words about perceived prosecutorial bias and what could be done by the ICC in order to dispel any myth about the perceived politicization and bias. So the second part of my talk, I would like to say a few words about the Icc Performance Indicators. So the ICC has been in operation for 15 years right now. And it has been spent over $1 billion on the functioning of the court. So of course there have been some questions raised about what exactly the court has achieved. And looking at the timeline, one can see that we have only 4 convictions delivered by the International Criminal Court, and that's a rather poor record for the institution that has been in place for 15 years. So that's why there has been this focus over the last 3 years that there should be some qualitative and quantitative indicators how the work of the International Criminal Court should be measured. The assembly of the ASP introduced certain criteria, and judging from the last report, the SAP wants to measure the efficiency of the International Criminal Court by looking at the fairness and expeditiousness of the proceedings, by looking at the transparency of the work of the court, and as well looking at the measures of the ICC as effective leadership and management, and the very last, which I think is probably one of the most important criterion, that's the victim's access to justice. I think when you look at this criteria that the SAP has been introduced to measure the effectiveness or the efficiency of the International Criminal Court, they're quite one-sided, as 3 out of 4 indicators that have been introduced, they deal with operational indicators. So basically, like how many judgments the court has produced, the proceedings have been fair, have they been expeditious or not. But I think there is an important point that the ICC is here missing, and that's what's the local impact of the International Criminal Court. We know that the ad hoc tribunals, the ICTY and ICTR, have nearly wrapped up its work. The ICTR did already, but ICTY has still a few pending cases. And there was a study which was published last year about the minuscule local impact which was achieved in particular by the ICTY on the ground, and about the level of distrust that the local communities have towards the court. So I think that the court has to learn from the ad hoc tribunals and has to make sure that it doesn't only achieve its functional indicators, but also it can produce meaningful local impact. And that, of course, should be done by cooperating with stakeholders on the ground, by understanding the dynamics of the court, having a greater greater focus on the role of the victims in international criminal justice, and focusing not only on the retributive aspects of international criminal justice, but as well on its restorative aspects. As well, when such performance indicators are in place and they are introduced, they are implemented, this will be a very useful tool for the ICC prosecutor, one can say, that could exercise self-reflection on the quality of its work. So these are the 2 major points that I wanted to raise in my talk. As well, I would just like to conclude a few words about what International Criminal Court can do for Ukraine. And I will be very brief because I'm sure that you heard a brilliant talk by Professor Gnatovsky already. So just few points of criticism. First of all, Ukraine expects that the International Criminal Court will intervene and will deliver some credible justice, in particular with respect to the Maidan crimes and the crimes that were committed in eastern Ukraine. However, I would like to say that in order for this to happen, Ukraine has to be sure that credible and robust evidence is being furnished by national authorities to the International Criminal Court. What it seems right now is that NGOs in Ukraine have been doing fantastic work by sending evidence and communications to the International Criminal Court, while the national authorities have not prioritized these cases properly. And I read somewhere in the news, not sure whether it's true, whether it's rumor, but there is only one person which is working in the Ukrainian General Prosecutor's Office collecting the evidence about the crimes against humanity committed during Maidan, which I think should be an absolute priority of national authorities. So my point is that although there is an expectation that International Criminal Court will intervene, but Ukrainian national authorities should also do its work properly and furnish the court with a robust evidence. Second point, and I think this point was already made by Professor Gnatovsky during the conference on post-conflict justice in Ukraine, is that one should not expect that the ICC prosecutor is some kind of superhero or Wonder Woman who will just come to Ukraine and will sort out all the problems and bring all those responsible to justice. Even if we have some potential prosecutions in the ICC prosecutions will be limited to 2 or 3, maybe 4 suspects that are accused of the war crimes or war crimes against humanity. The International Criminal Court will not be able to prosecute every single person who was somehow involved in the crimes that were committed in Ukraine. Therefore, it's extremely important the national authorities do not only do proper job by collecting the evidence and furnishing the International Criminal Court with the robust evidence, but that as well national authorities are the ones who are prosecuting these crimes. In particular, low-rank perpetrators should be convicted within the national system for the crimes for the crimes that have been taking place during Maidan, and as well for the crimes that that are still taking place in eastern Ukraine. The very last point that I would like to make, and I stop here. Ukraine wants the International Criminal Court to prioritize the Ukrainian case, but it seems that Ukraine does not prioritize its ratification of the Rome Statute. It was quite strange for me that last year, when the constitutional amendments have been implemented in the Constitution of Ukraine, the constitutional provision says that the entry of the Rome Statute into force is only expected in 3 years, which is in 2019. So that seems very strange for me that Ukraine is employing such delay tactics. I think if Ukraine wants the International Criminal Court to be serious about investigations of the crime that is still taking place in Ukraine, it has to ratify the International Criminal Court with immediate effect and stop playing political games. And I think I will stop here.
Well, thank you very much, Irina. Any questions, any suggestions from the field? Welcome.
Thank you. Thank you for your presentation. So my name is Daniel Nedvetsky. I'm a student from Institute of International Relations, and I want to ask you a question. I heard a lot of criticism for Ukraine, for its work, not only from you, but from all of my professors in my institution. And now I would like to ask you, but do you personally see any positive perspective for Ukraine anyway in the ICC? Thank you.
Yeah. Thank you very much, if I can answer right now. So I do think that Ukraine has really good chances for its case to be heard by the International Criminal Court. As you know, Ukraine has submitted 2 declarations accepting the ad hoc jurisdiction of the court. The first declaration concerns alleged crimes against humanity that took place during the Maidan protest. And here the ICC prosecutor already decided that she does not want to move forward with the Maidan crimes because she doesn't believe that these crimes constitute crimes against humanity within the framework of the Rome Statute. And I wrote an article which was published earlier this year by Boston International Law Journal, in which I argued that Maidan crimes do fulfill all the legal elements of crimes against humanity. But here it's quite crucial that the national authorities of Ukraine submit new evidence from which the ICC prosecutor could infer that the systematic requirement of crimes against humanity in the context of its attack against the civilian population has been met. So I'm not sure what's gonna happen with respect to Ukraine's allegations that concern the Maidan crimes. The case might not move forward if new evidence is not being submitted. And I know that there was some evidence which was already furnished by the NGO to the International Criminal Court, but more has to be done by national authorities. The second part of the second declaration of Ukraine deals with war crimes that are currently being committed in eastern Ukraine. And here I think Ukraine has really good chances for the case to move forward. First of all, crimes against humanity and war crimes in eastern Ukraine have been widely documented by international organizations. So here the prosecutor does not have any doubt where the crimes have been committed. The second stage of the ICC prosecutor's evaluation will be whether national authorities have done something about prosecuting these crimes. And so far as I know, not much has been done. Unless the situation remains unchanged and national authorities are unwilling to deal with these crimes, I think that there is a really good chance that the International Criminal Court will intervene. But here, of course, there are many expectations. So some expect that the rebel leaders that the rebel leaders of DNR, LNR will be prosecuted. Some hope that Russian officials will be prosecuted for the crimes committed in eastern Ukraine. But one has to be quite realistic about it, because if the court decides in connection with the situation in Ukraine to bring charges against nationals of Russia that has a permanent seat in the UN Security Council, that will have very far-reaching consequences and serious implications. So I'm not sure whether from a strategic perspective the first suspects that the ICC prosecutor will go after will be Russian nationals. It could be that just purely from a strategic perspective, the first suspects that the ICC prosecutor will go after would be the leaders of non-state groups operating on the territory of eastern Ukraine. I can say more about it, but maybe some others have questions, and if you're interested, you can send me an email. I'll be happy to share with you my work that I already published about the prospects of Ukraine's case before the International Criminal Court.
Is there any suggestions? Maybe you want to say or share some words about the ideas Dr. Marchuk has given us. Well, thank you very much. I hope that your ideas and you're sharing the meaning of understanding what we have to do in the field is concerning the first is for inhabitants of Ukraine, concerning the role of Ukraine in this process should be of great interest to us. I just remember that in this field and in this university we were the first who were drafting the law on immunities of the members of ICC, and Mr. Kivalov was the rapporteur of this law, and sometimes 10 years ago, well, we have discussed this problem, the problem of implementing the ICC bylaw into ICC statute to national legislation, but the case is the case. Politics is one field, when legalizing spheres is the second one, and sometimes they are not run in the proper way, in the proper manner. Maybe Judge Shaska will say some words about all the situation and all the issues we are sharing upon us. Yes, no, but that suggestion, that's the end of moderation, because now we have, due to our programs, we are just working. Yes, that's the end of the program. Maybe you want to say some words about it.
Thank you very much, Irina. It's nice to see you again. And,
nice to see you as well.
See you that you are very active and devoted to international criminal justice. So it's very nice. I wish you success. And you are our future now regarding ICC. And in conclusion, I would like to say that we have very interesting first day today. I think all presentations were very interesting, and we all learned some new things, and we will think also about what is happening, and we'll try to find a decision or to contribute what to do better or what to do different. So I wish everybody a very nice evening, and see you tomorrow. Thank you.
Well, distinguished ladies and gentlemen, well, as a moderator of this session, I want to say that it is closed, and I wish you a pleasant evening. Just don't forget that it is an Indian summer. An Indian summer is the grace period of time in Odessa. Well, the water is warm, the weather is warm. Well, I don't know what I want to say in this situation, except one old joke. You know that here in this city, we have Jewish cemetery. We have a Jewish hospital, but we don't have a Jewish newborn house because Odessa citizens are not born. They are beginning to be. And you are beginning to be an Odessa citizen after the first Indian summer eve in this city. I very proudly welcome you to enjoy it. Thank you.
Small technical announcement, if I may. You have already this information in your folders, but today we are waiting all of you in the Kumanets restaurant in the center of the city. We will have a kind of national dinner there. Again, you have this information in your folders, but the non-alcoholic beverages and some starters are already ordered and paid by the organizational committee. And for the main courses and maybe alcoholic beverages, you have to cover this part by yourself. But in any way, we are waiting for you at 9 in the Kumanets restaurant. Those who are going to the Opera House this evening will